Welcome in the ring, and welcome back to our special coverage of Decision Day, the elections petition ruling on preliminary matters. Welcome to all. Welcome in the ring to Decision Day, our special coverage of the elections petition ruling on preliminary matters. And we have a few folks who are going to be joining us in a bit. So I want you to be on standby for that, folks. But it is Decision Day. It is Decision Day. And I hope that you guys would have been listening to that decision by Chief Justice Roxanne George Wilshire. And all I can say is, wow. Wow. I'm going to leave some of our commentators to give better context to what you may have heard. I know you may have your own thoughts as well, but we want to wait on our guests to join us to give us some more context to what we would have heard. I don't necessarily want to put my views out there right now. This is one of the times I really want to hold back and allow them to do what they do as professionals in this area of law. Even though I am trained on the subject matter, I'm not as practiced as they are. So I want to wait for the folks to join us back again. This is Decision Day. Again, the elections petition ruling on preliminary matters has just concluded. And so a decision has been made, or decisions have been made. And we are holding for our commentators to rejoin us. And I am advised that the hearing is now wrapping up and they're going to be with us shortly. So let's bear with them. A very, very lengthy ruling started at 1:30, I think it was, almost on the clock at 1:30. According to my watch at this end, it is now 3:37. 3:37. And so we are awaiting our colleagues to rejoin us as we give you some more context, some more commentary, some more insight into this decision, this ruling on preliminary matters in the elections petitions cases. There were 2 elections petition, as you know, and we are waiting on our colleagues to rejoin us because we want to bring you valid and credible information, as always. Valid and credible information. That is what we are holding for. So our colleagues are going to join us very, very shortly. But just to take you through some of the preliminary issues, as you would know, there were 2 elections petition. And let me just walk you through them very briefly as we hold. There was petition 88, the first petition, and this one argued that the recount order was illegal and unconstitutional, and therefore the results announced on the basis of the recount is illegal and unconstitutional. And petition 2, the second petition rather, petition 99, established clear fraud was committed in the March 2nd elections and that the results arrived at are fraudulent on the basis that over 115,000 votes were affected as a result of illegitimate and fraudulent votes, which benefited PPPC. So, folks, there's where we are at the hour. I want to welcome one of our commentators who is going to be joining us, Rickford Burke, this afternoon. Rickford is the president of the Caribbean Guyana Institute for Democracy, CPGI. He's a political commentator as well. Rickford, very good afternoon and welcome.
Thank you. Good afternoon to you, and good afternoon to your listeners.
Rickford, what do you make of the hearing as of the hour?
Well, I'm not surprised. I have been saying that this would have been the outcome, that the Chief Justice is going to make sure that the PP gets its desires. This Chief Justice has politicized, to me, the court. She is falling in the same vein of Carl Singh and Ian Chan. I think the fact that she, without conducting a voir dire, without conducting any kind of inquiry, can arbitrarily determine that the affidavit by these two persons who effected service on Mr. Granger is basically she's saying it's false, and she applied her own truth or not or whatever to that, and determined that basically they're lying, and that they serve.
I'm going to play the devil's advocate. I'm going to play defense. But she did make the point that even if they didn't realize that the petitions were serious in a manner in terms of how they were supposed to be served, when they would have gone back for the second time to come back and say that the date was not affixed to it, or the correct date was not affixed to it, showed that they were not taking what they did very seriously, and the rules spell out very clearly, meticulously how the petitions should be served and other issues.
Well, I don't think it's her job as a court to determine whether or not they're taking their job seriously. I think her job is to determine the facts. And the facts that were before her was that both of these people who effected service on Mr. Granger testified that he was served within the correct date, which is on the 18th. But let me say this, I have a mixed reaction to her judgment. I agree with her that Mr. Granger is a necessary party. I mean, if the prayers of the petitioners are granted, and the relief they seek are granted, it would indeed affect elected members of the National Assembly from the APNU-AFC list of candidates, which Mr. Granger represents as the representative of the list. So I agree with her that it does affect that. I agree with her that he's a necessary party, and the case laws that she cited are relevant and apt in the case. I, however, disagree with her arbitrarily coming to this conclusion that the affidavit filed by these two persons who served Mr. Granger were incredible. She has to go with what she has. She can't apply for her own mind and what she feels to it. So the fact before her was that these people did serve Mr. Granger, and that there was a mistake on the date. That's the evidence before her. I think the Court of Appeal is going to take a second look at it and make a determination. I'm eager to see what the Court of Appeal and the Caribbean Court of Justice says.
Yeah, and we did say, we have been saying that either way, either party are going to take this matter to the Court of Appeal and then ultimately to the CCJ. So we're in for the long haul on both counts. But it's on that note, I wanted to bring our viewers up to date in terms of where we are. There were two petitions before the court, petition 88 and petition 99. What were the success of those petitions as of the hour? Let's jump off from there.
Well, she said one petition can proceed, which is the one challenging the validity of Order 60, which is the order that reshaped the election law. From my reading of what she's saying, she said that the first petition, which has the actual evidence of the fraud, cannot go forward. She said it's a non-starter from the time they made the mistake in the date on which Mr. Granger was served. I think he's the second respondent, that it was a non-starter, so she's going to dismiss the petition, or she has. I didn't hear the entire, the end of the ruling. But in effect, based on her comments, she's going to dismiss petition number 1, which has the evidence, right? That's important. Petition number 1 has the evidence outlining all the fraud, outlining the fact that persons who were dead voted, outlining the fact that persons who were overseas voted, and the evidence showing that these people are dead, that these people don't live in the country, that they were not present in the country. All of that has been dismissed. And so, she has been very consistent in ruling to make sure that the desires of the PPP are met.
Yeah, and River, I want to add, just in terms of some of the issues that are on the content that will be knocked out, because I see you did go through quite a few of them, but in addition to that, you got things like certificates of employment.
Exactly.
You have oaths of identity that goes out the window. all of those issues that that were looked at, and one realizes that several key things were missing. I'm trying to gather my notes at this end here. So let me just run through some of them quickly for the purpose of our viewers. With petition 99 going out the window, we wouldn't get a chance, for instance, to put before the court these missing certificates of employment, to talk about those persons who would have died and somebody fraudulently voted in their stead, those migrants who would have been overseas and somebody voted in their stead on March 2nd, those who did not have ID cards, but very strangely seem to have voted without any oath of identity, and the list goes on stamp ballots.
And most importantly, the fact that they counted votes in ballot boxes which had no documents validating these votes. All of that evidence was in petition number 99. So it is not only you wouldn't have a chance to present them before the court. The evidence, the actual facts showing death certificates and the persons were not in the country who live abroad that voted, and persons voted without identification card, and the evidence that persons who were supposed to present certificates of employment showing that they worked with GCOM and were allowed to vote, that these documents were missing, but the votes were counted. So all of the evidence to support fraud in the election has gone out the window.
Yep, and looking at some other figures that we wouldn't get a chance to prosecute, for instance, we looked at some of the migrants seem to be 3,400 plus persons who would have been out of the jurisdiction and strangely voted on election day. Missing oaths of identity over 1,100. Unverifiable oaths due to missing poll books 897. Unstamped ballots over 400. Missing poll books over 400. And remember, every poll book represents a polling station. Missing certificates of employment.
And hundreds and thousands of votes, possibly thousands of votes.
Yeah, so this is the situation at the hour as it regards to election petition 99, the more evidence-based petition. Go ahead, Rickford.
Well, like I said, the Chief Justice has been a reliable source for PPT, the PPP receiving its desires, and she's living up to her true characteristic, which is ensuring that the PPP gets its desired. I think this judge has politicized the court, just as Justice Ian Chan has, just as Carl Singh has. I make no apology for saying I think she's fundamentally opposed to anything that the AP and UAFC wants to do. I guess, I don't know if it's revenge that for the fact that President Granger shunned her and wasn't recommending her to be confirmed in the job or what. Even in my case, I criticize her decision with regard to the no confidence motion. And a matter came up, a lawsuit that I brought came up where the Guyana Times libeled me. It was fully acknowledged. They claimed they apologized. They never apologized. But she used the claim that they apologized and said that no damage was done to me, even though these people lied and said that I stole somebody's credit card and bought a Range Rover. And they published that. And they never apologized. They went before her and claimed that they apologized. But she dismissed it. It's now appealed. But I think, again, that was not based on law and fact and the circumstance. It was based on some sort of, to me, retribution. But I could be wrong. I'll give her the benefit of the doubt as the Chief Justice, but I think she's been a reliable supporter of the PPP in the judiciary.
All right. Richard, in another aspect of this ruling, 99, the Chief Justice seemed to have expanded tremendously on those persons who were entitled to be served. I think I didn't remember in the case management hearing either of the litigants raised the issue of members of parliament being served. She seemed to have expanded on that. And
well, she's saying that the members of parliament should be served through their representative of the list. I happen to agree with that. It's to me, you can't challenge. This is the issue. What she's saying is, if you challenge the election, even though some of the prayers that you're seeking, some of the relief you're seeking, are not in conflict with a particular list, the fact that you're challenging the elections and persons were elected to parliament and the RDCs pursuant to that same elections, the
And
fact that
occupied those seats.
And
occupied those seats as well, not only
occupy
elected.
those seats, there's a conflict because you're challenging their election, and if your relief is granted, those people will lose their seats, and they'll have to have new elections. So I agree with that. My issue with her is I don't understand the basis on which she determined that the affidavit of the persons certifying that Mr. Granger was served on a particular day were incredulous. She just said to her mind, right? As a judge, you don't rule based on your mind, you rule based on the evidence before you. And you had two people corroborating the fact that Mr. Granger was served on a particular date, and that there was an error on the date of the affidavit of service. I don't understand the basis on which she's disputing that. She did not conduct a hearing to question those people and determine their credibility in the stand, and if they had determine if they had additional evidence or whatever. She just said to her mind. That's nonsense coming from a judge.
Yep, and the thing with that one is, Rickford, with petition 99, that both sides in the March 2nd, 2020 general and regional elections have claimed fraud and have claimed rigging. And this same Chief Justice has said on numerous occasions that the place to determine rigging, I think she said it this afternoon again, is the High Court through an elections petition, because she spoke to fraud and all of that. And so we will not have a final determination on the March 2nd general and regional election whether or not there was rigging.
Well,
and we are joined by our colleague Randolph Critchlow. Randy, welcome, my brother.
Hi, Randolph. Good afternoon, my brother. How are you? Good afternoon. Before Randolph, let me just comment on that. Listen, I agree that the place to challenge fraud is an elections petition. I don't agree that you can count invalid fraudulent votes and then say go challenge it in an election petition. In no jurisdiction in the world, you knowingly count invalid votes. Invalid votes are weeded out at the time it's being counted. So that's where they changed the law. Now, let me say, Sharon, the fact that there was a mistake on this petition was highly irresponsible and reckless. I participate in election matters here in New York. There's strict guidelines within the law, within when service should be given and all of that. And what we do, we don't allow the service processor to just submit an affidavit of support and we then attach it to a document and file it with the court. The attorneys, we check it ourselves. We sometimes even the date when you're sending out it to be served, we put the date on it. So it's a serious issue. My problem with her is that she is making an arbitrary determination that the people are not telling the truth, and she has no evidence before her based on what I've seen and what I've heard her say, that they're lying. Basically, that's what she's saying, based on her own feeling. And as a judge, you don't go on your feeling, you go on the evidence before you. And she had two people testifying that Mr. Granger was served on.
Randy?
Good afternoon, Sherry. Good afternoon, Rickford. And happy that you guys have started the conversation. And I want to just pick up on something that Rickford mentioned. It seems as though that there's an accommodation of the PPP's requirements and the things that they need. And I will say this. I mean, I am not the lawyer, but based on my observation, not only now, but all through these proceedings, all through the elections hearings that we were, there seems to be a constant leaning to facilitate the position of the PPP. We know, Guyana knows, the world knows that the mountain of evidence that was uncovered that shows that there was fraud in this election is something that will taint the reputation of the PPP. And it seems as though, you know what, we can't afford for this evidence to move forward. And we are going to find this technicality And I'm going to take it upon myself to, as Mr. Burke said, you know, throughout the affidavit of the two persons who deposed that, look, this was a mistake. He was served on time, but the mistake was a thing, and it was corrected. And to just say, you know what, the two of you are not telling the truth, and we are going to throw this thing out. So as to facilitate the position of the PPP, and not have all the evidence that supports that they committed fraud in this election put forward to the Guyanese people. But I will say they shared before you know we continue, that what happened during the recount, and whether the recount should have happened is another issue, but what happened there and the fact that we were able to go into those boxes will not be hidden behind some tree because of what happened today, right? That information is out there. That information will be laid before the feet of every single Guyanese. All of what you mentioned just now, the 40-something boxes without any documentation, the persons who voted without any sort of voter event identification, the dead persons, the overseas persons that voted, all of these things are now in the public domain, and Guyanese will make up their mind. I am trying to control myself today before I'm accused of inciting. I know that's a word that has been going wrong. No, but you know, I am one that believes that at certain points in time we have to stop talking and we have to take action. And the evidence is there. And if it is that the system is not going to allow the evidence to be put forward and heard properly, and a decision made off of those evidence, and then I believe that the people have a responsibility to act outside of just rhetoric. And, you know, go ahead, Sherrod.
Let me put this there. Rickford, was the Chief Justice leading the prosecution when in the case management, it was the Chief Justice who raised the issue of whether or not Granger was a proper respondent, which said to me, she was convinced at that point that he was not. Now she comes and ruled that he was, as leader of the list. It seemed very, very strange because she was the person who raised the issue that Granger was not a proper respondent because he was not at cross purposes with the weight of the petition.
Well, I have said it all along. The Chief Justice concluded that he was not, and that the petition must be thrown out. And then she sought the time from when it was the hearing to December 18th today to find the reasoning to apply to her decision. That's my view. I've been saying it all along. I made a post about it. I said she will rule against it because she's trying to find a purpose to suit the PUP's desire, which is to throw the petition. I have no apologies to make. I think this Chief Justice, as I said, has politicized the judiciary. She wants to make sure that the interest of the PUP is preserved in the judiciary, and that's why I came out and said that she should not be confirmed. One of the things that I want to follow up on something Randolph said that is very important, and it's a mistake. You know, some APNU AFC leaders and supporters don't like when I criticize them, but I'm very pragmatic. I think the AFC, from the time they were in government during this whole election saga, from the no confidence motion, have been putting their eggs in the basket of the judiciary, which has not worked out. Listen, this is politics, and politics is about people, and the voices of the people must be reflected in the judiciary. In America, right, where I live, the judiciary has over time come around to the position of the society, right? Legalizing certain things, abolishing certain things, ruling out certain things, you know, applying better standards to some social justice issues, recognizing racism, outlawing it, and so on. That is because of activism. What has been absent in the strategy of the coalition is people activism, and they will continue. The coalition will continue to be injured because it is failing to have a proper strategy, whether it's in the judiciary, or not, or in parliament, or whatever, you have to be supported by the strength of your support base. And until they recognize that, they will continue to have these defeats. Listen, the judiciary is completely opposed to half of the population of the country, right? I have a lot of respect for the chancellor of the judiciary, but she's just one person. I have a lot of respect for a couple of judges, right? But they're just individual judges. The judiciary,
just hold a second for me. Let us welcome Attorney at Law 𝐓𝐡𝐞 𝐑𝐢𝐧𝐠 member of Parliament as well. 𝐓𝐡𝐞, welcome to the discussion. Rickford, go right ahead.
Yeah, as I was saying, that and I'm being so frank because I know my colleagues who have to practice in the judiciary in Guyana and live in Guyana would be more cautious. But I am adamantly opposed to what this Chief Justice has been doing to the judiciary, and I'm adamantly opposed to the strategy that we must not employ the people, pressure from the people in anything that the coalition is doing. It's a mistake.
Thanks, Rickford. 𝐓𝐡𝐞, the Chief Justice, Justice George Wilshire, has ruled, as it is decision day, that elections petition number 99 is a nullity and is dismissed. 𝐓𝐡𝐞, I don't know what's happening at your end, but Rickford, are you hearing me?
I can hear you, but there's a horrible feedback. Are you hearing me?
Let me try to solve that. Yes, I'm hearing you clearly.
Speaking could mute their mic.
Rickford, try to mute your mic and let's see that with him. Go right ahead, Manson.
Yes. Sorry, Sharon, what were you asking?
So I was saying the Chief Justice, Roxanne George Wilshire, has ruled election petition number 99 as a nullity and it is therefore dismissed. I think the major issue there was service. Your thoughts?
I think on the program before we expressed our views as to how we thought it could possibly go. Like I said in my introduction, a petition is going to be heard either way. I am not as pessimistic. I'll tell you what I'm concerned about. I'm concerned about the fact, let me back up and start off by saying that it is not acceptable to me that such mistakes could be made in the service of a document. I wish to be very clear on that. Very, very clear on that. It's not excusable. Having said that, however, we know enough to know that this is a defect that could be cured by the court if they thought that they should. There is enough jurisprudence to show that procedural matters such as these need not negate hearing the case on the merits. Now, what people have to bear in mind is that the merits of the case have nowhere been touched.
Correct.
All right. So I have a different view. I actually believe that the intention, the result of this is that what you have standing and unchallenged is the findings of what the recount showed, because that is irrefutable. So you have 47 ballot boxes without statutory documents. This elections petition would have afforded the opportunity for all of that to be either, well, not either, because it has been proven. That is a fact. There were 47 ballot boxes without documents. And so proceeding along that line would have allowed us to delve into that matter some more. The fact that you have not even gotten to the merits of the case really does say that a couple of things, I believe. The fact that the PPP was so adamant that this should not proceed is that it would have confirmed what everybody knew. And that is that they were the riggers of the election. The fact that it did not go forward, particularly to their base, allows it to remain the conjecture of the APNU AFC. You understand what I'm saying?
Yes.
And so they are able to save face because they can say this is the conjecture of the APNU AFC. And that is how they're able to save face to their base. So when I see people post, it's thrown out and whatever, what they do not realize is that it has done, while it appears to be inimical to the interests of the AP and UAFC, it has done more damage to the PPP because they have been unable to prove to the Guyanese people that they did not rig the elections. You see? And so I wanted to, let me just finalize my initial reaction. So I don't despair. To my mind, all of Guyana would have been better off if that matter had proceeded and heard on its merits, because once and for all the questions would have been settled. And so the fact that it is now left to the realm of, okay, this is what we found, to me, to any right person, any person who sits and thinks to realize it, why would you not want this to go forward if you're so confident? Why not seize on the opportunity to once and for all nail the coffin, put the final nail in the coffin of the AP and UAFC? You did not make use of the opportunity. What more a resounding victory it would have been if you had the court side with you that these irregularities did not happen, etc., and throw it out.
As against the technical knockout of the petition on grounds of service.
As against the irregularity of service. Now, it raises another conundrum because when you, and this is just my initial reactions, when you hear the Chief Justice's reasoning, to my mind, she has said that the fact that there are seats in Parliament that the AP and UAFC must defend is in essence a conflicting interest, and therefore the leader of the list is a proper party. But it harkens back to the point that we were making in our previous discussion, Sherrod, where Tabitha, if you recall, raised the point that generally US elections are challenged before there is a swearing in. So based on what she has said, it is not unreasonable to conclude that whilst in Guyana, the situation is that you have to have a declaration before you can have a petition. The question arises, does me taking the oath of Parliament, the oath of a parliamentarian, is it to be construed as me now affirming the results of the elections? Do you understand what I'm saying?
Yeah, yeah.
Because if you're saying I have a seat to defend, I am saying, so then it becomes a circular issue. And it really does point to the fact that we need a reform, because you're saying there has to be a declaration before. A declaration means a president is declared, the National Assembly is constituted, and the business goes on. But because you have taken up your seat, or because there is a seat. And so these are just some of my initial reactions. I am sure there will be I'm sure that there'll be an appeal, but I am disappointed. I'm very disappointed that that she did not hear the case on the merits, because it's important to the future of Guyana that the case be heard on the merits. And we will continue. And to my mind, this is more fuel this fuels our energies. Because if you listen, the only people afraid of the law is the lawless. So if you were confident that you didn't rig, allowing things to proceed, let's trash it out once and for all. But no, you came on a technicality, which to my mind is so, egregious to my mind, given the historical juncture at which we are. And this is important, that we assess the ability of our courts to be able to apply law in the context of the current environment. Do you understand what I'm saying, Rickford?
Absolutely, and
Listen,
listen, I'm a little more radical than you are, as you know, and you're being a very nice diplomat, and as you are. But the Chief Justice is the one that raised this. She, in essence, was the person that raised it, that concluded that it was not, and found the reasoning to support her conclusion. She, it was clear to me what she intended to do from the time she raised it, that there was improper service. And I have been saying all along that the fact that there was this mistake is so completely irresponsible. How do you put a wrong date on a petition for the man who was part of the office in which this petition is emanating, and was present when it was filed with a photograph posing? Like, just serve the damn man right there, let him sign the damn thing right there. But anyway, that's aside. The point, and I don't really mean to criticize my colleagues who worked so hard on this petition, but I think that like Amanda said, it was an egregious mistake that should not have happened. Well, she didn't say that. I'm saying that. But coming back to what Amanda said, listen, the PPP today successfully blocked the election petition from being heard. The Chief Justice was complicit. Right? They blocked it. This is not necessarily, I don't think we should package it as a technicality. The PPP is blocking the petition where all the evidence of fraud resides, right? They successfully blocked it. It's going to go to the Court of Appeal. I think that the society should express its views that this petition should not be blocked. Let the courts hear the merits of the evidence that we presented, evidence of fraud, evidence that dead people voted, evidence that people who were abroad, living abroad, still on the voters list, but not present in the country voted, evidence that persons voted without ID cards, thousands, evidence that people who supposedly are GCOM workers voted without any documentation that they were, evidence of the fact that thousands of votes were counted on the East Coast that were found in ballot boxes with no supportive documents to verify whether they're legal or not, evidence of the fact that invalid votes were counted. And the fact that they're blocking this from being heard is reprehensible. And the Chief Justice, as I said, is continuing along the lines of Ian Shannon Carsing in politicizing the courts to make sure the desires of the PPP are met. And it's unacceptable. And like I said, I disagree with Mr. Harmon that she should be confirmed in that position. She's now a source of tremendous conflict and controversy in the country. And we need a Chief Justice who would apply the law based on facts and circumstances and precedent. She's not doing that. And I want to reiterate my point. The judges determine cases based on evidence and facts before them. The evidence and the facts before her were that these two young people who served Mr. Granger said he was served under 18. She has nothing to contradict that. She did not conduct a voir dire. She did not conduct a hearing to question these people's veracity, to question Mr. Granger, to see if there's a conflict. Anyway, she just said to her mind, they're not telling the truth, and she ruled on that. It is reprehensible, and the judiciary is heading in a terrible, terrible direction, and that's why there's no trust and confidence in the judiciary. We have a problem in the police force, and we have a problem in the judiciary. I'm not sure how do we correct it.
I made the point earlier when we were talking about the importance of democratic institutions such as our parliament and our court. And we were making the point that the issue of the failure of these institutions very often is what precipitates what you see happening with movements like the Black Lives Matter. These were not political movements. They were birthed out of, it is a popular movement that was birthed out of the discontent of the people. And I have always maintained that unless the people of Guyana decide that this is not acceptable, we will continue to go down this road. We keep looking, and rightfully so, and we have to hold our political leaders accountable. But at the end of the day, if you notice how Black Lives sprung up, people are just tired, they were just fed up and said, enough is enough. You know? And so for me, it is, I find that it's just, it's ridiculous. It is perfectly within the remit of a court to say, look, given what Guyana has gone through, given all of the allegations that have been made, all of the evidence that is before us, this matter should be heard on its merits. This is about the healing and reconciliation of a nation. To my mind, what has been done is that the divide has been further widened because there is now no basis for unifying the people. Because at least you could have had the ability to rally around to say, look, they ventilate this matter thoroughly in court. These were the findings. Let us now build from here. But you do not even have that. You do not have that. And so the people are robbed. This is not the AP and UAFC. And, you know, I very often ignore the narrow-mindedness of the PPP supporters. Because they're very, you know, some of them are very basic people. So you have to see with them.
Right.
But the people
right.
are being robbed of an opportunity to have consensus. And we talk about nation building, we talk about healing, and then our courts take decisions like this that could precipitate people mobilizing because they are upset. And you know, and so my point is that the court has to be more responsive to the temperature of the society, Rickford. And the court has to appreciate it. It has to play a role in tempering.
I made that very point, and I pointed to the fact how the laws and the Supreme Court decisions have changed over time to be in line with the thinking of the society, and that's what angers me with what is happening in Guyana. And I want to say that they're perfectly fine judges in Guyana. I have absolutely the best admiration and respect for the chancellor. I think that maybe the chancellor needs to look at what's happening in judiciary. Maybe the politicians. Listen, we have to force the country to the positions that we want to see come out in the laws, either in the parliament or the courts. I think 50,000 to 60,000 people should go in front of the Court of Appeal and let them know that this petition should not be blocked. Let the courts hear this decision on the merit, not block it based on some procedural nonsense that the Chief Justice thinks in her gut feeling somebody's lying. No, that's not how the courts function. The Chief Justice has before her evidence by two people saying, we serve this man on a certain date. The affidavit of service has an incorrect date. How does it injure any party by correcting that date based on the testimony of these people? Like I said, I have a mixed review of her judgment. I agree with her that Mr. Granger is a necessary respondent as the leader of the APNU list. When you look at the prayers and the relief sought for in petition 99, if they're granted, they would affect people like Amanza because she's going to lose her seat. So in that respect, I agree with her. My problem with her is this arbitrary determination without any basis at all, that the affidavit that these two people brought before her are incredulous. They're unbelievable. She's saying that they don't have any credibility. On what basis? I don't know. Her gut feeling. And judges should not do that. especially on such matters of national importance, where that could spark chaos in the society. That decision that she just made there could spiral up, could send.
Precisely, Rickford. No, you are absolutely right. And so this is why you have to, nobody can fault you for coming to the conclusion that the only thing people will respond to is mobilization. How can somebody fault you for that? When you see you are abiding by the courts, you're abiding by the rule of law, and it continuously fails, this is what is causing the society to decay, because the court is now failing to perform that balancing act. I agree, something as basic as service should not be bungled. But I also know that if the court wanted, there are enough authorities in the law to say that we will cure this defect and we will hear this matter on the merits because of the national importance, because of the importance of this case to the healing of this nation, because it is important that the nation close this chapter to be able to move on.
And I
go ahead.
I wanted to bring Randy in his mobile, and then I want to come to
Sharon, I was saying
looking at the glass half full. Randy?
Yeah. I agree 100% with Amanda and Rickford here. The nation was expecting some sort of closure. The people of the country are expecting that the facts, not the opinions and the conjecture of somebody, that the facts that were uncovered during the recount would come to bear in a court of law. The fact is that these things are there. Nobody's making up the fact that 47 boxes had no documents. That is fact, and that will remain fact. And this is the problem with what has happened today. That will remain fact, and we will continue to be in this place of unease because there is no sort of closure. Now, what will you tell the hundreds of thousands of people who saw those things, including PVP supporters, and who are now wondering whether or not their party actually did this thing? Who will always be thinking, well, maybe Irfan and them, they were lying to us. What about the APNU supporters who know that this thing happened? The court, as Amanda said, has a responsibility. And now we are still in this place of unease and uncertainty because this is now left up in the air. The fact are there, but we can't hear the fact in the court of law. And it's a real unfortunate situation if you're talking about healing and moving forward. And I will not be surprised if the people take this as the final straw. I am very sorry. Call me the inciter in chief or whatever. But I for one, tomorrow.
You're not inciting.
Tomorrow.
Anything. You're expressing an opinion.
Right.
You're not inciting. You're expressing an opinion.
Right. Right. Tomorrow I will be standing right in front of the court. Tomorrow I'll be making sure that business is not as normal. I'm saying if it was up to me, and I'll be there, because this is utter madness, and because this matter is so important to the nation, because this is such a matter of national concern and importance, to leave it up in the air at this point in time, is just unacceptable. So what about the evidence? What are you supposed to do now? What are the Guyanese people supposed to do with all of those evidence, those facts that were unearthed? Just try to wait and forget that it happened? How do we move forward as a nation from this? Those are questions that I'm wondering if the court didn't consider. How would the nation move forward given that all of these things are on the table and you cannot hear them? It's a real sad situation. Sure.
Sorry for bothering you. Jump in there, guys.
No, I was gonna make the point,
Yeah, Sharon.
Sharon, springing off of what Randy said. You know, this opportunity to disprove was important for the PPP, and the fact that they didn't take it to the people who wish to employ their intellect will tell you exactly what that means. So you know, I am not discouraged. I've always maintained that there's a place for the people to agitate, and if the people, you know, as you say, it could very well be the last straw. It could very well be the last straw. So
I want to, yeah, I want to raise the issue of the number 88, petition number 88, as looking at the glass half full, because we have belabored the point that 99 is gone until the Court of Appeal says otherwise. But we still have 88. And on the bright side, because it's a less evidential based petition, it might even be heard and concluded faster. What are your thoughts there?
well, interestingly, what has been happening is that the respondents, some of them have been seeking now to introduce evidence, particularly 𝐓𝐶om. So I think the judge has entered a return date where she will take submissions on that issue. So indeed, the glass is half full, but I think the Guyanese people feel robbed. We feel robbed of the opportunity to ventilate these matters. And I really want to say to our people, ignore the foolish people that will come to bait you with very nonsensical comments. You understand, you can think, do not allow them to bait you into stupid exchanges. It just does not serve purpose. We need to be focusing our energies right now on moving this thing forward and crafting the strategy to complement the legal strategy as to how we are going to move this forward. So I, for one, I am not hopeless. I am not despondent. I am concerned, however, that instead of taking a fire extinguisher to the situation today, a match was struck. That is my concern.
Yeah.
And I'm afraid that people are just going to have enough, and we will end up in a precarious situation, because with people, of course, gathering, you'll have increasing the COVID numbers, and we will be heading down just an abyss. And I thought that the court would have taken the opportunity to stem that today. I truly thought so.
Thanks, Samantha.
And Sherrod, what I had a discussion with Nigel Hughes last night on my program, and I mentioned the fact that in relation to the Henry boys, maybe it's time for international intervention. I'm increasingly of the view that the people who are in charge of institutions in the country, the people who are supposed to guard our democracy and ensure that we have a rule of law, are increasingly failing us or acting in the interest of one set of people. And it seemed to me that the only way we'll be able to correct the situation is with international influence. And so to the extent that the international, are you guys hearing me? I'm not hearing you guys.
Rickford, I can hear you loud and clear.
Okay, good.
Sorry about that.
Sherrod, can you hear me?
Yes, I'm hearing you now. Sorry about that.
Okay, I was just seeing you talking when I'm talking, so I thought you were saying something.
Sorry about that. No, I am actually, Roysdale has the coalition's response to the ruling at 4:30. So I'm trying to see if we can pull the feed through our end here. Go right ahead. Sorry about that.
Oh, you were just mute and talking.
Yeah.
Okay.
Yeah, we talking. Sorry about that.
Okay. So I was wondering, just let me know when to shut up. I was wondering if there is some way now we have to get the international community involved to course correct, or because we're going off the cliff in Guyana, right? We're heading off the cliff. There's no relief from that people are getting from the judiciary. People are losing confidence in the judiciary. Only the PUP is getting results in the judiciary. Only the PUP is getting results in the Guyana Police Force. The Guyana Police Force and the Chief Justice is there protecting the interests of the PPP in the judiciary. She didn't even assign this to another judge, even though she has become so controversial. If I were her, I would have assigned this to a judge. Why take this responsibility where you'll be clobbered over the head in any case, either way? But she took it on because she wanted to make sure that she protects the interests of the PPP. I have no apologies to saying that. That's what she's there for. And so we need to, we need to make sure, to me, that the international community steps in and brings some balance back in Guyana, or else we're heading off a cliff. Because at some point in time, even though people are saying Guyanese people are docile, they're tolerant, or APA supporters are accepting this one, at some point in time, this situation is going to get out of hand when people realize the police force is not a police force, the judiciary is not a real judiciary, and we have a government that is only governing for one set of people. The pressure cooker pot will fly off, and something dangerous is going to happen in the country. And so maybe the international community has to step in and bring some balance back, bring the parties together or something, and force a resolution. There should be another elections in the country. Whether the judiciary wants to make sure that happens or not, or it happens as a result of people pressure. I like the people pressure part because I'm a radical, or I could get radical, but I think the judiciary has an opportunity now to hear this case on the merits to determine whether or not these elections were fraudulent. And the Chief Justice has joined with the PPP to block it.
Now, Rickford, and Cheryl, what I'm seeing is there appears to be some misconception on what has happened. There are some people who have the view that that President Granger did not submit the papers on time. That is not the case. What happened is a disservice of the judiciary.
Cheryl, can you mute the microphone?
Want to cut away?
No, hold. Go right ahead, folks. I will tell you when. Sorry about that.
Did you hear anything that I just said? Because I think my mic might have been on mute.
No, you go right ahead. I was hearing you clearly.
Okay.
Yeah, we were hearing you.
I will. No, I just wanted to make that point. That this could precipitate a situation that we have been trying for a very long time to avoid. And because there is so much misperception in terms of what has happened, it has to be made clear that the AP and UFC did not submit anything late. Everything was filed in time. However, there is a process of service. And so the process of service is what there was an error in.
Service to the other parties.
Service to the parties, because I noticed there is a preponderance of ignorance about, you didn't submit this in time. President Granger had nothing to do with the issue of service. And so that has to be made clear, and that context has to be brought to the situation so that people speak intelligently on these matters. Having said that, like I said, it is a rare, and Rickford, you live in a far more advanced, a place with a far more advanced judiciary. It is a rare thing to hear a matter thrown out on the fact that it didn't serve it. And so people take this as a victory, not understanding that you have deprived yourself of an opportunity to prove your innocence.
Right, and that's why I said that I would be saying, and I think this matter should be packaged to the people. I don't like the word package, but it should be related to the people that the PPP, that the judge sided with the PPP to block the petition from being heard because of a wrong date on a piece of paper that was corrected. And like Amanza said, everything was submitted in time. It's just that the parties who participated in the elections had to be served with the petition. And then once they're served, an affidavit of service on these people had to be filled out and filed with the court to verify that all the parties were served. It is on that piece of paper that was served on Mr. Granger that there was a mistake in the date. And the people who served him attempted to correct it by saying, hey, we served him on this date, but somebody write the wrong date. And she's saying, no, I don't believe you. That's the date you served. And that is incredible to me. Like how the France, for want of a better word, you can jump to the conclusion without no evidence that these people who say, I served this man on this date are not telling the truth. That's what I cannot fathom. On what basis she came to that conclusion? She's just saying to her mind.
Let me say this, Rickford. I want to make this point. You know what is most devastating for me on this issue is that our people are not surprised at the ruling.
Welcome, Clark.
Correct.
That is worrying to me, that our people are not surprised. Like, yeah, we expected that. What else? So it is almost an acceptance that this is the way it is. We don't accept, but we cannot be content with that. We as the people have to change that. And I'm speaking now as a person who was born and raised in Guyana. We got to change that.
Mansa, I'm asking both you and Rickford if you have the time with me this afternoon to let us take Roy Zale, Senior Counsel, his statement on behalf of the coalition when he begins to speak, and then we can pick up and get some reactions to it afterwards.
Sure.
Great. So we can go ahead and finish that comment you were making. I don't think he's on as yet.
I just want to follow up on something Amanda said. Amanda, I don't think it's that they have accepted it. I think they've come to realize that this is what the Chief Justice would have done. That the PPP, along with its supporters in the judiciary, would have gone all out to block this petition from being heard. And people are not surprised, even though they're angry, that this is what they actually went ahead and did, even though we were saying we hope you won't do that, because we know this is the PPP. They're ruthless, right? They will go all out to make sure this petition is not heard. And the fact that the Chief Justice has facilitated it and blocked it on this procedural issue is stunning to me. I mean, in New York, all hell will break loose, right? And we saw what happened when courts continually in the summer kept on acquitting police officers who murdered Black people. The people forced the change. Right? And I want to tell people to draw inspiration, not from the insurrection, but from the Black Lives Matter. Because over 30 years, people have been fighting for laws that hold people accountable for racism. And it didn't happen. But it happened when these young people came out in numbers from all races. Yes, some of them trashed the place and tore the whole place up. But maybe that's what needed to happen for us to have a reckoning. And within a week, laws were passed, and CGID participated in that. We had a rally that had close to 50,000 people, right? Because people were so angry and outraged at what happened to George Floyd that they can kill a man on live TV and think they can get. Are you ready to start?
Thanks for coming at such short notice.
They are getting set, folks.
Okay.
Go ahead, Rickford.
Yeah, so just let me button that up by saying, so we saw how that change happened. And I want the people of Guyana to draw inspiration. It's fine for yourself and me and Amanda to come on and analyze these situations and bring context to what is happening and give an interpretation of the law and what we think somebody should do and how they should behave. But it's a different thing when the people feel that they are being trampled upon, that their rights are being denied, that there's two sets of standards for different people. Like, for instance, we look at the DPP, right? She would draw the charges over certain people, all rich Indians, right? And poor people who are suffering, some people who have been charged unjustly for things, because of a different race or a different category in the economic status, they're in prison awaiting trial for years, for decades, right? And people like Nandalala and Ashley Singh and Michael Brassington had on charges that the courts authorized. Remember this. the courts authorized were just dismissed, right? What do we do? How do we quell the outrage of the people when there's such injustice, blatant injustice in the society? When the judiciary is acting in a certain way, like the Chief Justice has been acting throughout this whole period, right? What do we do? And I think the people should speak.
And you know, Rickford, this is what I've been saying, that really, really and truly, the BLM is a popular movement. The population is what drives it. And I think very often people do not, you see when something is homogeneous and it springs forth, it is of the people and it brings lasting change. A lot of times, things that are politically engineered, you know, is not as impactful. And I always say the people will have it so. So however it is that the people have to stand up. We see the disrespect all across the divide. From the Nancy story, we are expected to believe of the Henry boys and their murder. We don't have an answer as to why Harish family isn't calling for justice strenuously. So you see a consistent, and let me say this, you know, I generally take a different view of things. The inability, people are not stupid. And the PPP, by its own actions, will condemn itself. Because a government that is committed to governing in the interest of the people would have ensured that that matter is thoroughly ventilated. A government that is interested in governing for all of the people will ensure that export help is available to solve the murders of the Henry boys. So I'm making the point because the point is that these are all symptoms of a problem. These are all manifestations coming from a particular root of a problem.
And you know what it says to me? What is unfolding in Guyana is people in the judiciary, people in the political spectrum, and people in law enforcement, and generally within our polity, are engendering a one-party rule state. And there must be resistance to that.
Will commence as soon as he does.
Well said,
Thanks again for your
Rickford. So we're getting ready here for Senior Counsel Ford, as you heard, to make his presentation on behalf of the coalition on the ruling by Chief Justice Roxanne George Wiltshire on petition 88 and 99. And so, folks, stay with us. We are going to go right to that. Manza and Rickford, please stay with us. I'd love to have your reactions when he concludes. Stay with us, folks. We are waiting for Senior Counsel Roysdale Ford, again, who is going to be, who is having a press conference.
Just confirming that the folks who said they didn't get the link now have it.
And we are already picking up some of their audio.
Great, thanks. You're at the office?
So, folks, we're holding for Senior Counsel Roysdale Ford. He is having a simultaneous press conference, and we're pulling that in via Zoom. They are going via Zoom, but we do have the feed for you. And so we ask that you stay with us, and we're going to have some reactions after Senior Counsel Ford's presentation, his statement to the media. We're going to have some reactions afterwards. So stay with us, folks. So, folks, again, we are holding for Senior Counsel Roysdale Ford, and Roysdale, as you know, is one of the lawyers in the petition matter.
Welcome.
Randolph, can you take your audio off for me?
Feedback from Sherrod's program at your end. Is there some way that we can turn that audio all the way down. I believe Randy would be able to assist. It's down. Okay, great. You can proceed now. Ready to start? You can proceed. Yes. Okay, one moment. Let me just send a live link. We'll start momentarily. I am back. Good night. Hello? Am I on there? You're on MP Ramjatan. We're about to go live, but we're getting a feedback from my thing. Yeah. Let me just. Certainly be appealed because we are of the opinion that the decision is incorrect, with the greatest of respect to the Chief Justice. The decision made by the Chief Justice in relation to petition number 99 centers around the alleged failure to effect service on Mr. Granger within the time frame required by the rules made under and in respect of the National Assembly Validity of Election Act, Chapter 104. There was before the Chief Justice affidavit evidence which indicates conclusively that Mr. David Granger was served with all the documents as required by the law. The Chief Justice, in her opinion, came to the conclusion, firstly,
I'm not on, but wait a second. Huh? A couple minutes. Sorry.
Of the students or other Commonwealth the respondents will have their submissions and reply by the 5th of March, and we will have to file a reply if necessary by the 19th of March. And the date of the 7th of April would have been fixed at 9:15 before the Chief Justice. Efforts were made by counsel for the PPP, Mr. Barajagio, and the associated parties to convert that petition into a petition which raises issues of irregularity on the part of the income. And this is a petition filed by the PPP. There is no basis in law for the respondents to file a defense or to take any effort to convert this petition.
I have some challenges. I think I just got the audio sorted out.
Such a position was rejected by myself representing the petitioners and the court of the
I know. I have both now. I've got the audio and the video. I can still bring in afterwards.
Written submission only. I think that would have summarized the position where we are in respect of these elections petitions, and we're willing to take questions. Thank you very much. Understood by all the just to clarify that there are two petitions, and one cannot proceed, but the other can. And we just want to emphasize that point. Already that suggests that both petitions have been dismissed. That is not the case. We will now open the floor for questions from the media. And if you can, as usual, use the raise hand feature within Zoom to indicate that you'd like to ask a question, and Senior Counsel Ford will be very happy to respond to you. So, ladies and gentlemen of the media, we'll take your questions.
Guys, welcome back there. And we were bringing you some, and we know we had some real challenges with some, but we are working through that. And we are going to have Mr. Royce Ford on our program at 8 this evening. So whatever you missed this afternoon, we really were trying to get you the song there. We're going to cover back at 8. Mr. Ford is going to be live in the ring in our special decision day coverage of the elections petition ruling on these preliminary matters in the elections petition cases. As you know, by now, the petition number 99 has been deemed or declared by the Chief Justice to be a nullity and has been dismissed, but petition number 8 goes forward. So I trust that you stick with us. We're gonna wrap up just as our commentators come back in. Rickford, I think, is still with us, and Amanza Walton Desir. Rickford Burke, that is still with us, and also Amanza Walton Desir. Let me bring these guys in and get the reactions. I've also Randolph Critchlow has come back with us.
No violent application was
I have
made
challenges
in
sound
relation to the
at my end.
proceedings. It is completely irrelevant.
Rickford.
Hi. Well, I didn't hear much of what Roysdale said. I agree with the only part I heard. The only part I heard, I completely agree with. And that's when he said what I've been saying all the time. The only evidence before the Chief Justice was the fact that two people who served Mr. 𝐒𝐿 testified via affidavit or affirmed via affidavit that he was served on the 18th. And I'm not sure on what basis did she make her decision that these people were not credible. I mean, listen, the Chief Justice made up her mind since the 22nd that this petition should be dismissed. She's the one that made the observation of the court that the affidavit of service had the incorrect date. And she allowed the opposition to make submissions challenging, not the opposition, the PP, and the other parties to make submissions to challenge that. From the time she did that, I knew what she was going to do. And like I said, I've been posting all the time that this is what she was going to do. And she had hearings, I don't remember on what date, and she took about 25 days to make a decision. To me, in those 25 days, she went in search of arguments, positions, and case law to justify her decision that she made since the 22nd that the elections petition should be thrown out. And Mr. Ford, again, today reiterated that the only evidence before her was the fact that Mr. 𝐒𝐿 was served correctly on the 18th of August.
Manza, your thoughts?
I am just, and this comes back to what Rickford is saying, because I heard Senior Counsel Ford say that they have concerns about the facts that have been recalled. Now, when you have concern about the court recalling the facts correctly, we're in trouble. I mean, that's as simple as I could put it, because I'm sure I heard him say somewhere in there the factual basis, and that is important. That's very, very, very important. And so I am concerned, Rickford and Sherrod. I am very, very, very concerned about what we are hearing. I'm very concerned about what we are hearing, and his averring to the elections petition, the Validity of Elections Act, and the fact that it does not specifically say a time, but says a reasonable time, etc. What I am seeing is no attempt at a wide construction of the issues to allow for the petition to be heard. What I'm seeing is a very narrow view that has been adopted, and therefore it is like I am not looking for that possible avenue to allow this to be heard. You understand my point, gentlemen?
Yes.
And so that is worrying to me. That is very, very worrying to me. That that such a narrow construction would be taken, appearing to me to be wanting to achieve a particular result.
Correct. And there's a school of there's a school of thought, Manza, in law, as you know, called realism, which means that you take a position and then you kind of find every law to support why that is right.
Yeah.
It seems to be that is the case here.
Yeah, but for me, I don't. Our job is to really break down what has happened to the people, so that they understand, because everybody is not everybody. We're not all lawyers.
Correct.
And so it's important that we stress that while this is distressing, there's another petition. What I heard Roysdale just say as well, which I confirm from what I would have heard in my listening in on the ruling, is that there was an attempt made by the respondents, 𝐓𝐡𝐞 𝐑𝐢𝐬𝐧 et al., to have an evidentiary basis introduced in this. And so you see a deliberate, and maybe, you know, it is to be commended, a very strategic manipulation of it, because you have an evidence-based one here that you don't want to admit it, but there's a legal question to be determined that you don't want to admit evidence for. The introduction of evidence will necessarily stretch it out, will necessarily protract it. And so I want to believe that intuitively there is a fear that because it is a matter of law and that the calling of witnesses, that the show will be over too soon.
Right. Amansi, you know what I think should happen? I think they should seek to amend 88 to add the evidence to that. And let her say no.
Well,
Mansi, your audio has gone. I don't know.
sorry. It is not the respondents who are seeking to introduce the evidence.
I know what I'm saying. The petitioners should now do the same.
Well, that is an entirely plausible situation to take, and so it's a matter of strategy. Senior Counsel Ford explained that there will be an appeal. So this is by no means over. What it has done is agitate 49% of the population, and that is not good. That can never be good. I think Guyana would have been in a much better place if we had ruled that both petitions move forward and this matter is settled once and for all.
Well, the PPP does not want the petition to be heard. The Chief Justice has been a consistent enabler of the PPP desires in the judiciary, just like they have an enabler on the Court of Appeal in whatever his name, Prem Prasad's son, Rishi Prasad. Rishi Prasad, if somebody comes in and say, Bharat Jagdeo is a human being, and Rishi Prasad, if the PPP said, no, he's not, Rishi Prasad was like, no, Bharat is not a human being. I find here is what the case law says. And so the Chief Justice is doing the same thing.
Randy?
That's my view.
And Rickford, let me say this. Let me say that nobody can fault you for coming to that conclusion. You have evidence to support the conclusions that you are coming to. So nobody can fault you and say you're inciting, etc., etc. You are not coming to unreasonable conclusions, is what I would say.
Thank you.
Well said, Amansa. Randy, you just listened to Rickford's press conference. What were your thoughts? Sorry, you just listened to Mr. Ford's press conference. Apologies.
Well, I'm happy that I heard that he said that there will be an appeal, because I, as an ordinary flat-foot Guyanese, would like to see that the evidence.
I don't know if I don't think you're a flat-foot Guyanese, but go ahead.
And as a citizen of Guyana, I would like to see that the evidence that was uncovered during the recount is properly presented in a court of law, and that there is some sort of closure. I mean, it's like a festering sore on the minds and the on the country. And as a government, you should want to get rid of that sore. You should not want to carry this throughout your tenure. You should not want to carry this scorn of people saying that you are not legitimate, you're fraudulent, you are there via fraudulent means. And I will repeat this, if the PPP wishes a person to refer to them as legitimate, then they would want this. You wouldn't fight the process that would then legitimize you tooth and nail like this. It makes absolutely no sense. I mean, I was on my way over to the press conference, and I was stopped by some men, the taxi drivers, and they were asking, so what are we doing now? And that is the state of the people. That's the mindset of the people. It's as if, and Rick Ford said it, that we have relied so heavily on the judicial system, which is not a bad thing. That is not something outside of the norm. You expect that the judiciary would operate based on the evidence in front of them. But we've relied on it for so long, and we've not taken the other side of it, where action needs to happen. Agitation and things need to happen, so people understand. The people who are controlling a lot of things understand and listen. The people will move, right? And your unpopularity and the unpopularity of your actions are going to agitate the people. And I again, Amanda always hits the nail on the head. If the Guyanese people want it, if they want it, if they are fed up, they will move. And share to conclude, what I will hope is that as we rely on the judiciary, that the powers that be, and I'm speaking directly here to, I mean, inadvertently speaking to both you and Amanda, who are part of the powers that be, that we start to think about other courses of action, because it has been over a year now. We've been in the courts. We've been seeing with our own eyes how things are moving, and how the tides are shifting, and we can read the tea leaves. Many persons would have told you that, what, this is not a surprise.
Yeah.
The enablers will continue to enable the PPP, and so we have to start re-strategizing how we move. What I will say before I turn over the microphone is that, despite the efforts of the PPP to try to get this case not tried in the court of law, it has been tried in the court of public opinion, and we have to continue to ensure that every single Guyanese knows exactly what happened on March 2nd. We got to put it up on billboards. We got to put it on T-shirts. We got to ensure that we bang it in the ear every single day. This is what the PPP did. They must not sit in the seat of power for the whatever time they're in there, without people understanding that they are there via fraudulent means. That is my contention.
Great. Folks, as we go, closing thoughts from Manza, closing thoughts from Rickford. I know you guys have been with me for some time, and I'm so thankful.
Go ahead, Rickford. I yield to you.
Well, thank you. I think my thoughts are well known. I'm not, like Randolph said, people aren't surprised. I'm not surprised by the ruling of the Chief Justice. Again, I said the Chief Justice made a complete 360 departure from the evidence before her. I'm happy that Mr. Ford, in his presentation just now, supports what I said. Guyana is heading off the cliff, where you have people in the judiciary, such as the Chief Justice, going outside of the law to make sure the PPP gets its desires, which is to govern at all costs. I'm wondering what would be the cost to trying to govern a country that doesn't want to govern it, when half of the people are believing that it's legitimate. The courts, along with the PPP, the Chief Justice rather, is forcing the government on the people and working in tandem with the government to force the people to accept the election results, and working with the PPP to block the evidence from coming to the courts. I think the coalition has to change its strategy. In addition to working through the judiciary to seek justice, we must have a concomitant strategy to mobilize the people, to demand certain things from the state, of which the judiciary is a key part. And I think that if the coalition leadership doesn't want that, the people should take the initiative to rally themselves, mobilize themselves, galvanize themselves to make sure that there's democracy, and that Guyana does not shift towards a one-party state, to make sure that democracy is complied with, and to make sure that there's a rule of law that is upheld by the government and the judiciary. And to the extent that that is not happening, we're heading off a cliff to failed statehood. And as a Guyanese, I'm concerned about that. I'll be doing what I can to get the international community to get involved in Guyana, to make sure that we have a rule of law, and to make sure that the rule of law is upheld and the principles of democracy are upheld, and that the manner in which we practice our democracy is consistent with international standards.
Manzo, over to you.
I agree with Rickford. I want to add that, in my view, it is a Pyrrhic victory that the PPP has seemingly won, because you will never be able to answer properly the fact that if you were not guilty of rigging, why didn't you allow the case to be heard? And they're never going to be able to address that, because remember, the merits of the case have not been addressed. It does not change the fact that death certificates of dead persons in whose names votes were recorded has been presented. They have not availed themselves of the opportunity to debunk that. Even though you hear their supporters are there, oh, prove that dead people vote, prove that dead people vote. Death certificates have been presented. Persons who were out of the jurisdiction, votes were recorded in their names. That is a fact. People have said, hey, I was there, but it appears as though I voted. These are not things that have been contradicted. The fact that there are statutory documents missing from 47 boxes has not been addressed. Now, this is not conjecture. These are facts.
Correct.
And so the fact that you have not seized the opportunity to prove to your supporters once and for all that you did not rig and that you won by honest means has been lost. Now, I am proceeding on the assumption that they care, because they don't care. You know, because they know that the type of reasoning we are employing here is never going to be employed there. So they don't, they don't really care. So I keep saying that it is for right-thinking Guyanese to salvage this nation. Because where ignorance abounds, we're going to have problems. And so I believe that they have failed to acquit themselves of these very damning evidence, and they are content to sit in office based on 47 or 11,000 votes unaccounted for, based on dead people voting and so on, because basically they don't really care, right? Because it has never been about the people of Guyana at the end of the day. It is about enriching a handful of themselves, using the rest of their people as the props.
Manzo, and some of those issues,
No, and so I'll just end by saying that hope is not lost. What you are seeing is a continuous unmasking, so that when the day of reckoning comes, nobody will be unsure about who stands and who sits. Because you would have had an opportunity to demonstrate. Because you would have been given an opportunity time and time again to do the right thing, and you refused. So I am, hope in me springs eternal. There is another petition to be heard. I agree with Rickford that there is need for re-strategizing. Because I'm concerned that people are going to become agitated. I am concerned that people are going to become agitated. And then what do we say to them? What do we say to them in the face of manifest injustice? And so we as a people, we as a Guyanese people, have to make a decision that we want a better Guyana, because it's not, I'm conscious that I'm a politician, but at the end of the day, it's not going to be delivered by the politicians. It's going to be delivered by the people. who will then choose their duly elected representatives to represent their interests.
Fantastic. I just want to say that the silver lining of today's ruling is that the cup is still half full. There is another petition to be heard, as Manzo rightfully said, number 88. It's still to be heard, and I think it was a brilliant piece of legal strategy to file 2 petitions. I don't want that to be lost. It was a brilliant piece of legal strategy to file 2 petitions. I am with Manza on the notion that it was kind of untenable to have the service so a little sloppy there. But in filing 2 petitions, it was truly a brilliant stroke. And so we're going to record.
Sure. Before you I want to underscore something Roysdale said. He said that the court has evidence that all of the documents were filed correctly. That's what he said. If you look at the evidentiary basis of the entire petition, the court has evidence that everything was filed correctly. I happen to agree with him, even though there was a mistake on the date of the service document. In addition to that, I want to say something that probably would prove very controversial, but I'm going to say it anyway. I think the Chief Justice is playing to the audience of the PPP with her eyes set on the CCJ. And I think that's the entire motivation here.
Great, but I'm going to have Mr. Ford Roysdale in the ring at 8 o'clock, and I'm going to put that very question, that very statement to him, and see.
I don't think you want to put this forward. I don't think you want to put this forward.
Amanda Walton is the attorney at law, Rickford Burke, Randolph Critchlow. Folks, thanks for spending this time with me. We are going to be back at 8 o'clock in the ring with our special coverage of Decision Day, the elections petition ruling on preliminary matters in election petition 88 and 99. Folks, thanks for being with me.
Thanks for having me.
Thank you for having us.
And for those of you who are still with me, I want to advise you to continue to observe all of the COVID protocols as we go. Continue to sanitize, continue to social distance, wear your mask where it is necessary. COVID is still as prevalent as ever. And folks, and there you have it in terms of what came out of today's court hearing. We know that elections petition 99 was struck down by the Chief Justice as being, I want to make sure I get her words correctly, as being let me capture the words correctly, as being a nullity rather, and as such it was dismissed on the grounds that it was not properly served on the respondents. So election petition 99 was deemed by the Chief Justice Roxanne George Wiltshire as a nullity, dismissed on the grounds that it was not properly served. Petition 88, however, folks, goes forward. Petition 88 goes forward, and we're going to have this and more information with you with one of the, if not both of them, the lawyers in the elections petitions case, Roysdale Ford Senior Counsel. He's going to be with us at 8 o'clock, and hopefully some other persons as we give more context and we give you more information, credible and valid. Thanks for joining us. Thanks for spending this time with us. We are going to see you right back here at 8. I am advised that we are not going to have the afternoon rush this afternoon because of our extensive coverage during the course of this afternoon, but we are going to be back right here in the ring at 8. Folks, see you at 8. Let's fight.